Good evening, everybody. This is Jonathan Ginsberg, and welcome to my weekly live stream. This is September 24th, so welcome to fall. I hope everybody has had a good summer and is getting ready for the fall and winter, and the temperatures are cooling down. So welcome. Today I have a guest, Andrew Sindler. Andrew is an attorney, and I believe you're in Maryland. Is that right?
Yes, correct.
In the Maryland area, okay. And I actually first met Andrew at a convention, the NOSCAR convention back in Nashville about a year and a half ago. Saw him speak, and he's a frequent speaker at Social Security events and frequently comments on different issues in Social Security and shares his expertise on the listserv that many of us belong to. So I thought we'd have him on, and we're going to talk about various things in Social Security, answer your questions, and sort of just see how the conversation goes. So Andrew, welcome. Thank you for joining me.
Thank you for having me.
Absolutely. So before we start with the questions, let's kind of give me a little bit of a background on you, what you do and where you're at, and kind of how your practice kind of came to be.
Certainly. So I have been, good evening to everybody. I have been in practice for a little over 20 years. And about 15 of those 20, I have been a solo practitioner and a true solo, in that I've truly been a one-man show. I don't employ anybody. I take on all the roles and hats, paralegal, law clerk, you name it, which allows me to be a lot more individual and personal with my clients, because they know that they're not going through somebody taking messages and passing messages along to them. They get to me directly, which is kind of the approach I've taken to practicing in general from day one. You know, when I worked for a couple of different firms in my early years of practice, and I always enjoyed the client-centered approach to what I did. So when I first started practicing, I've done Social Security my whole entire career, but it didn't really take on a life of its own until about, I'd say, 2 or so years into practicing. I had done some other areas. I started off as a miserable year and a half of doing family law, which I couldn't get away from fast enough because of the stress of that. More power to those who can tolerate it.
Totally agree.
A little bit of minor criminal law, mostly personal injury and disability. That's always been my bread and butter. The second firm that I worked for before I went solo was the one that really helped me find my footing in Social Security. And my entry into that world and what really set me on that path was an experience I had. It was the first Social Security case I ever took. And I took this case at the first firm that I was working at. It wasn't my case. It was just a case that was assigned to me. And to be completely honest with you, you know, and especially for anybody who's tuning in here, if this seems like quite a minefield to navigate, it was just as much, if not more so, of a minefield for me when I started, because I didn't actually know this area of law or of Social Security even existed. When somebody mentioned Social Security, the only thing that honestly came to my mind was, hey, that's what my grandparents used to receive. I thought it was just strictly a retirement kind of deal, and found out that there's this whole other branch to it that's probably not as well known or advertised, at least not back then, and didn't realize that it's actually a tremendous opportunity of a practice area. And it's one that I've found over the years has been a very undervalued and underrepresented one at that. So this client actually, when the case got assigned to me, this claim was already a good deal of the way into whatever stage it was at. And I knew nothing about Social Security, but I had an attorney at this firm that did know about it. And he was kind of helping supervise me a little bit and explain some of it to me. And I was very upfront with this client, but she told me I was like the fourth different attorney that had been assigned to her in the time her claim had been going. And I told her, I said, I was very upfront. I said, well, look, I'm learning on the go. If you're comfortable with that, I'm comfortable doing this. I just want to be upfront with you. And she appreciated my candor. So I did what I could for her. Then when I left that firm, I was about a few months into my tenure at the second firm when all of a sudden she called my cell phone. Now, I know that doesn't seem like such a big deal, but this was 2007 we're talking about. I know that doesn't seem like it should be as long ago as it is. But that was back in a time where cell phone numbers were not exactly advertised, where you could just find someone or we were willingly sharing it like that. So she got it from that old firm, begged them to give it to her, and they did. And when she called me, she didn't think I would even remember who she was. I immediately did. And she said, they're about to assign me to the 5th different attorney. I don't feel comfortable with that. I was so much more comfortable with you. You were the only one that ever communicated with me. Seemed like you took my case seriously. Would you be willing to take it on? So my supervisor at the new firm, who did mostly personal injury, when I asked him, do you know anything about Social Security disability? His response to me was, I'll never forget this. He said, I know enough to get by. And I'm like, well, that's a vote of confidence.
Yeah, that's not good.
So I said, okay, I guess that's good enough. I told him, I got this woman that followed me from my old firm. Are you okay if I bring her in? That was a great prospect for a new associate to bring in a case. And we brought her in. The case ended up going to a hearing. It ended up being the very first hearing I ever did. It was in Washington, D.C. at their hearing office at the time with a judge that had been on the bench for a while, but again, knew nothing about it. I went to the hearing office and I had that deer in headlights look that there was another attorney in that office who I haven't talked to in a while, but I've kept in touch with over the years. He was much more seasoned than I am, and he sensed it. He saw it. He walked right up to me without even introducing himself. He just said, "Who's your judge?" Like he knew. He sniffed it out of me. He's like, I'm uncomfortable, and I want to get comfortable quickly. And I told him who the judge was. He told me exactly what to expect. He asked me a little bit of the details of my case. He said, "You're going to be just fine." He wasn't lying about that. We went into the hearing room, did a little bit of informal discussion, a little bit of informal testimony. The case was awarded on the spot, which I didn't know at the time wasn't a common occurrence.
Right.
And when we came out of the hearing room, this is one of those memories that's just etched in my brain and will be forever. This woman who was in her mid to late 50s, tears streaming down her face, tears of joy, gave me the biggest hug you could possibly imagine, and just told me how life-changing this was going to be for her. And that was the moment that galvanized me, where I said that this is what I'm meant to do. No question about it. Every other practice area pales in comparison. So that's where things took off. I started learning and growing. I didn't really have a lot of advantages as far as official or unofficial mentors or even really courses or things I could take. I was finding every resource I could. There were limited online resources at the time. And by the time I was getting close to leaving that firm in 2010, it got to a point where the senior attorneys of that firm were actually coming to me for advice and guidance on Social Security cases because they had been actually referring their Social Security cases out. And when I came to them and said, I would like to actually develop this practice and see what we can do with it, they said, have at it. We have a lot of, they had a lot of existing auto accident or workers' comp clients that were, that severely impaired and injured that were going to go that route eventually. And they said to themselves, that this could be a lucrative opportunity for the firm. And it did turn out to be for a while. And it was a tremendous show of respect and an honor to me that where I started with it just a few years prior, suddenly people are asking me, how do I do this? What does this mean? What can we do with this case? And I had grown my own little, niche of a practice. It doesn't sound like a huge number, but back then, a few years into practice in general, it was like grown to about 40 to 50 cases, which I ended up taking with me when I left that firm. So to bring the train back on the tracks a little bit, when I left that firm in 2010, I was not intending to go out solo. That was not my original game plan. I actually ended up going first when I left that firm, and the main reason I left it is because I had moved out of the area and the commute was killing me. I just couldn't continue doing that anymore. And remote work was not a thing back then. So my initial plan was to take those 40 to 50 cases and catch on somewhere else. I live near Annapolis, which is right halfway between Baltimore and DC. And I thought I would easily be able to catch on with another firm and have that asset of, hey, I've got a book of business to bring with me. And it turns out that was more of a burden than a benefit, because so many of these firms I would interview with didn't want the cases I was bringing, or at least didn't want certain kinds. And I didn't feel right about being able to take certain ones and not others and say, hey, you can come with me, but you can't. So months into this whole process, out of sheer necessity, that's where my solo practice was born. And then my career took a really unusual trajectory, because 9 months after I left that firm, and I just started this solo practice, I took on a full-time gig as an in-house general counsel and risk manager for a nonprofit health center in Baltimore that had been around for like 40 years. And I thought I was going to have to shut my practice down then, which I was willing to do because it was a full-time gig. I was like, okay, that's perfectly fine. And the CEO of this particular nonprofit actually said, if this practice doesn't interfere with the work you do for us, you can continue running it. We have a lot of professionals here that run their own businesses on the side.
Okay.
And it stunned me. Now, as it happens, somebody was looking out for me on that, because the fate of it was, first of all, there were some people that I was actually helping with Social Security that were patients of, this was like a health practice, just not a typical kind, because it was nonprofit specializing in uninsured and underinsured people that, were looking for, the typical type of free clinics and things of that nature. And that's what we were providing to them with federal and state grants and a lot of other things going on. So I worked there for 3 years running the practice. The practice kind of grew and took on a life of its own, primarily in Social Security cases and some other types too. But then the nonprofit suddenly and quickly went under. Long story, not worth getting into right now. If my practice didn't take on the life of its own, and if God forbid, I had shut that practice down when I thought I was going to have to, I probably wouldn't be sitting here talking to you right now. I don't know what would have happened to me, because I had that to fall back on. This was around 2014.
And it kind of grew from there.
Oh, and then some. And, the funny thing is, the way this practice grew was not the way you'd expect in this day and age with technology. This was really still very much primarily a word of mouth practice, that I was getting referrals from friends, colleagues, current, former clients, you name it. Over time, kind of fast forwarding to where I am now within the last few years, COVID obviously changed the trajectory a little bit, where we all pretty much went fully remote. Which, so for those of you who aren't aware of this, Social Security really has had the capability of doing both remote hearings and just remote work in general, well before COVID kind of forced it on us. And I think they just came to realize how much more efficient at times it can be, which is why I'm very grateful that we are where we are now.
Let me get, because I want to get, because I know I've got a bunch of questions. So I want to get to some of those, but let me just start by asking, because I know, again, it's interesting. Your story kind of parallels mine to some degree. There was no, great plan to get into Social Security, just kind of happened. And, you meet the right people, and the next thing you know, you're doing this full time.
Right.
Let's kind of segue to, you're talking to a prospective client. I'm just always ask this question of people, because we all have several different approaches to it. You're talking to somebody. How do you, when you're talking to somebody brand new, you've never met before, how do you tell them, what does it take to win a disability case? How do you define what disability is? How do you explain to somebody what it's going to take to win?
Sure. Well, I'll give you a little bit of a Reader's Digest version. I'll put in a shameless plug for myself, because I do have a YouTube channel that I started about 2 years ago that has a lot of informational videos on different aspects of the Social Security disability process. Each video has its own PowerPoint with it. So if you're a visual person like me, it's very easy to follow. The very first video I ever did was basically a Social Security 101. I call it the ABCs of SSD. So it breaks down the process. It talks a little bit about the what we refer to as the 5-step sequential evaluation process. I'm not going to go into that, but essentially, a new potential client calls me up, wants to know if they have a potential case. So first of all, I go through a series of about 3 or 4 mainstream questions. The first one is, how old is the person? Second one is, what's their highest level of education? Third one is a 2-parter. When did they stop working, and what type of work have they done within the last 5 years, what we refer to as the past relevant work period? And then fourth, and most important of all, what medical impairments do they have that they believe are preventing them from working full-time work? So once I go through all that and kind of get the basics down and see if it sounds like it's got potential just on that alone, that's where I start explaining to them first the general definition of disability, which is essentially having one or more severe medical impairments that prevent you from working any kind of full-time work. And then I might start going into a little more of a specific explanation, depending on the circumstances, particularly for the the group of people that are age 50 and up, where there's a special set of rules I'm sure we'll talk about at some point called the grid rules that potentially make the path to disability easier, although at times I've also found it makes the path to disability a little bit harder. But basically, what I'm trying to get across to them is that whatever their impairments are, while it doesn't have to be the type of impairment that makes them a complete invalid, because that's not what Social Security disability is about. That's not the standard. If that was the standard, hardly anyone would ever get approved. But I do explain to them in no uncertain terms that you really have to, the key word that I use, and I've used this in many of the presentations I've done as well, is consistency. And in this case, it's actually more so lack of consistency. You have to be able to show that whatever your impairments are, physical impairments, mental impairments, both, you have to be able to show that you are not going to be able to consistently attend and perform any kind of full-time job, no matter how simple and unskilled the job is, and no matter how physically demanding the job is or isn't. Because if there is at least one job that exists enough in the economy that you could do on a full-time basis in spite of your impairments, that's going to be enough for them to warrant a denial of your claim. And it's, it sounds more complicated than it is, and it sounds more overbearing, but that's essentially one of the main things that I'll tell people right off the bat.
Is reliability and dependability is what I'm
absolutely.
Okay. All right. Let's talk about that, because the questions that, and again, these are the questions that I get week after week. Time frame. I have my typical explanation of the time frame. How do you explain the typical time frame for a case from filing to a hearing decision?
Okay, so one of the things I'll tell people right off the bat, even though I don't like to get too far ahead of myself, is claims can take a good amount of time, primarily because they often have to go through multiple levels after the initial filing. If the claim gets the typical initial denial, which many claims do, as you and I both know. So I have to explain at least a little bit about some of the different levels of appeal. Now, I don't necessarily go all the way to the highest level, because that's so far down the line and potentially one we will never see. I'll usually just give them the tidbits of the initial application stage, the reconsideration stage, the first level appeal, and then the request for hearing stage, the second level, where many claims will eventually get to. So generally what I'm doing now is I'm breaking down the time frame of each of those periods. And one thing that I've found, and I don't know if this has been your experience recently, it used to be pre-pandemic that a claim at the initial level would be the quickest.
Right.
Reconsideration would be a bit longer, and then the hearing level would be off the charts long. I would tell people, if we get up to the hearing level, the minute I request a hearing, expect it's going to be at least a year before we get one scheduled. And I think part of that was because back then we were doing nothing but in-person hearings, and the dockets were just too clogged and not enough.
That's changed. That's changed now, hasn't it?
It's not only changed, but it seems like it's actually completely flipped a 180, that it's now the initial level that seems to be taking the longest, partly because these caseworkers at the DDS, Disability Determination Services offices across the country, they're way too short-staffed, and they don't have enough personnel to handle what they need to. So those parts are taking the longest. I'm finding most of my claims are taking a year or more at the initial level. But then the reconsideration stage, I'm finding, is usually only taking a matter of a few months, maybe 6 at the most. And then requesting a hearing, I'm usually seeing hearing dates within 2 to 3 months of requesting it, and they're only scheduled about another 2 or 3 months out from there. So really a 6-month lag from hearing request to hearing occurring. And then usually no more than, where it used to be at least 60 days minimum for a hearing decision to come out. On average, I'm seeing 30 to 60 days, and sometimes even shorter. So
and I just got 3 or 4 of them in. I just checked today, and with 2 weeks. I mean, it's rare, but I mean,
it is.
Yeah. So, I mean, it sounds like your experience is kind of similar to mine, and that it really is maybe 18 to 24 months typically. Unless you get it done early. Is there anything that that you've found that will speed up the process? Anything somebody can do to get the process expedited?
Well, it's a combination of 2 things. First of all, prompt and swift communication at all times, starting with the field office when a claim is first filed, and making, at least for me as an attorney, and again, I don't know if this has been your experience, but pretty much since the pandemic, almost every case I take on nowadays is a case that has not been filed yet. So I'm starting from scratch with most of my new clients. Whereas pre-pandemic, most of my clients were coming to me after they've been denied once and many times twice, and they're at the hearing stage and they don't want to go before a judge without an attorney. But I'm finding that when I'm first filing a claim, sometimes I get immediate access to the claim file within like maybe a couple weeks. Other cases are taking months before I have that access, and it's either nothing's happening on the claim or somebody hasn't uploaded my information.
Right.
So I am constantly, with regular diary reminders on every single claim file, I'm constantly calling these field offices and making sure that they're doing what they need to do to get me in the system, so that once I have online access to the claim file, and now with what we can see in the online claim file at these earlier stages, it gives us a lot more advantage to know what's missing and what we can get in there. Now, one of the things I also do, and this is a regular part of my practice as well, and has been for many years, is I always make sure I have at least a good representative sampling of medical records at the ready before I take a case on, partly because I need to review it to make sure it's a viable case, but also I need to have those records ready so that when this case is in the system and I have online access to it, I can immediately get in there and file those records to get that ball rolling. Now, granted, with the new electronic record system they have, electronic medical records, that is, where
you're talking about the HIT, Health Information Technology.
Right. Where Social Security can now compile records from many different sources, hospitals primarily, but even a lot of regular medical providers and practices, where they can just go online and just click a few things with a mouse, and suddenly you've got hundreds of pages of records in the file within the first week. And that's something that definitely has helped speed things up. The other component of it is, once the case is at DDS and is assigned to a caseworker, and we as attorneys now know that because we see the status change. And as soon as that happens, that's when I'm immediately on the phone with the caseworker to introduce myself, open the lines of communication. What can I do to help you get this thing moving? Whether it's filling out the forms like the function report and the work history report, whether it's getting records in, giving them medical sources to get records from, everything and anything I can do to speed it up and follow up, that's what I'm doing. And that has helped overall. I mean, claims definitely probably go a lot faster from that alone than anything else.
Okay. And I guess my next question was, is there anything you can do to try to win an initial or recon? And it sounds like that's really kind of what you're telling me, is you're getting you're opening the lines of communication with the adjudicator. You're asking them, and I asked this question: what can I do to help you do your job?
Right. And if I get one, there are some caseworkers that legitimately care, and that actually, the presentation I just gave at the most recent NASCAR conference in San Diego a couple weeks ago, one of the things that I said to my audience at the time is, I'm predicting, I'm going on record right now, I'm predicting our listserv that you mentioned earlier. One of the most common questions we see shared from attorney to attorney across the country is if we have any intel on a given judge. I think it's only a matter of time before we are going to start seeing questions of, do you have any intel on so-and-so caseworker at DDS? Because I'm finding that my relationships with some of these caseworkers that I run into over and over again are becoming the same kind of relationships I have with the judges. And I'm also seeing the same kind of patterns of, there are some caseworkers that I term like the good type of judges that care and that want to actually see my clients get their claims approved and are not going to try to just push through a rubber stamp denial like certain other ones. So yes, that's definitely one key aspect of what I do at the initial and recon stages to be able to try to get claims approved. The other big thing is, I mean, and this kind of goes without saying, this is something we prepare to do as attorneys in general, is that we have to have a clearly outlined theory of the case. We have to know if there's a potential listing met. We have to know if there's a potential grid rule at play, and we have to be able to play up. We're not doing anything formally in writing. We're not writing up briefs at this stage necessarily, but I I can call a caseworker if I'm familiar enough with my claim and say, take a look at such and such medical record, page, blah, blah, blah. That's what's going to show you the objective finding. There's an MRI in there. There's some kind of imaging study. There's an FCE in the file, functional capacity evaluation, that shows my client, who did all of their past relevant work at the medium or heavy level, is limited to light or sedentary, and they're 50 or 55 years old. They grid out.
Right.
We do not need to waste time on this. Some of them are more receptive than others, but I'm getting those theories outlined from the earliest point I can, because I know that's going to follow me along as I go through other levels if it gets denied. And that's
I actually put those arguments in there's a comment section at initial recon. I put it in the
that's
comment
exactly what I do too.
Please evaluate this case under grid rule 202.06.
Because
the person
I do the exact same thing.
All right. Let me ask you a couple other questions, because you sort of touched on this. Age, how important, when you're looking at a prospective case, how important is age? You mentioned that age 50 cutoff for the grids. Is that something that's a key factor when you look at a case to possibly take it?
So age obviously is a relevant factor. Unlike, sadly, I know that, I'm certainly not naming any names, and I'm not looking to malign anybody here, but I know from experiences I've heard about, there are attorneys and firms that at times will refuse to take a case if someone's not at least age 50, unless their disability is just that clear. And that's saying something. I've never subscribed to that line of thinking. I don't think that's right. I almost think it's its own form of age discrimination even. But if I find out someone is under age 50, even if they're close to it, then certainly I'm probably going to scrutinize the claim a little more, not because I'm being discriminatory, but because I know Social Security is likely to be, and they're going to scrutinize the heck out of it, and I don't have the grid rules to potentially fall back on. Now, on the flip side of that, if I do have a client that's age 50 or up, and they do have physical impairments, not mental health, and they do have a history of physically demanding work, then I have to start sort of picking apart, okay, I almost have to play devil's advocate a little bit of, how is Social Security going to evaluate this? Because I've been finding this in very recent times. I don't really understand what the trend is here, or if there is a trend, but I feel like cases that to me should be the most clear and obvious grid cases known to man, they're going out of their way to find a way to come up just short and lead to a denial on it. A lot of times it has to do with the idea, if it's 50 to 54, we know we have to prove sedentary, and they're finding light. If it's 55 and up, we know we have to prove light, and they're going to find medium. And, the other thing too, is that I've been finding at the initial and recon levels, these caseworkers, whether it's because they're just lazy or they don't understand, and the medical consultants they're working with don't seem to be putting in the extra level of work to realize, just because you can't satisfy a grid rule, or because you don't think one is satisfied, that doesn't mean this person isn't disabled. You're not looking at the big picture. You're not looking at time off task and absenteeism concerns from pain or fatigue or symptoms like that. And basically, it's gotten to a point where more and more caseworkers are subscribing themselves to the line of thinking, if you don't clearly meet a listing and you don't clearly meet a grid, regardless of your age, they're not going to find you disabled. So age is becoming less and less important at the early levels to me. If I have age on my side for a potential grid argument, I'm certainly going to use it to my advantage, but it's not going to be an all determining factor for me. And God knows I've taken on many claims over the years of people well below age 50. So I know the grid rules don't even factor in, and that's fine. It's about the quality, not quantity, as far as I could say.
Do you find for people over 50, or even people, let's say at 48, 49, are you finding that at the state agency level, they are changing the onset date to a threshold date, and therefore cutting out past due benefit?
Oh, yes. I've had several of those occurrences in the last year, and I have appealed every one of them. And as we speak, I'm still working on. I had another case where it wasn't an age 50 grid case, but it was a listing case. The evidence clearly showed that my client met the listing well before the onset date that they determined, and it perfectly aligned with her alleged onset date. They gave her an onset date about 2 days after they made the decision, or 2 days before they made the decision. So they made the decision on May 9th, said
Right.
she became disabled May 7th on the basis of a test her own doctor did. And I was just flabbergasted by
Yeah.
that.
I
And yeah, I'm
I
seeing a
wonder
lot
if
of that.
there's you wonder if there's sort of a, unwritten rule that let's save the agency money by
Mhm.
approving people, but change the onset because you put them in a very awkward position. Do you
Absolutely.
appeal a partially
Mhm.
favorable decision and take the
Right.
risk you get a bad judge and you lose everything? And I've
Right.
look, I had a case about 2 months ago where
Mhm.
they changed the onset date, and ridiculous in my opinion.
Mhm.
$100,000. My client was out $100,000 by
Wow.
changing the onset to, literally $100,000 of past due benefits to zero. And he didn't
Wow.
want, he's like, I don't want to take the chance. I'm like,
Right.
look, you're crazy. I understand, but you're crazy. I said,
Yep.
the odds of you getting denied are just so slim here.
Right.
But he didn't want to take the chance. Like,
Right.
okay,
I just had the same thing with a client of mine. She didn't lose all of it, but she lost most of it and
yep.
still didn't care. And I and let me be clear to everyone watching here. Um, and I'm sure you subscribe to the same line of thinking. In those circumstances, one thing I'll always make very clear to my clients: I'm not motivated or driven by a desire to get a higher attorney's fee, despite the fact that you and I both know
Mhm.
we operate in a system that doesn't seem to benefit the work that we attorneys do because we are so limited in when we can get paid and how much we can get paid. And it hasn't kept up with the times. I mean, it's improved a little bit in recent years, but not the way it should be by this point in time. And we work and fight like dogs for our clients, and get scraps left over in most cases, and those are one of the ones where we royally get the
Yeah.
hammer thrown at us.
Yep.
It's terrible, but it's never something that I'll say I want to encourage my client to appeal something that they could be taking a risk on, simply because I know if they don't, I'm going to get either screwed out of an attorney's fee or I'm going to get a very low attorney's fee. That's not the way I operate, and that is
On here.
the risk I take doing
I'm
this
there.
work.
Okay. Yeah. You froze up for a second. So
Yeah.
basically, what you were saying was that
Mhm.
you would never recommend somebody appeal simply because of the attorney fee issue, which
Correct.
again, and I sometimes get this people will say this, well,
Right.
the attorneys purposely delay it so they make more money. Absolutely not, because
Nope.
you
Not
don't
at
want
all.
to take a chance with a judge. Look at every hearing office. There's
Mhm.
one judge, two judges who are 20%, 15% approval.
Right.
The last thing you want to do is to risk a partial approval, and you get the judge low approval.
Exactly.
So you take your wins where you get them. But yeah, it
Absolutely.
gets really frustrating when they make these very arbitrary decisions to change the onset date. I
Right.
see it a lot. People, let's say they're 53 when they file their
Mhm.
onset date, and they move them to 55, no
Mhm.
past due benefits. And you look at the filing like, what are you possibly thinking? But it is what it is. All right, let me ask you this, because this is another question I get
Sure.
quite frequently. Um, Obviously, people are stop working when they file for disability, or they work very little. They may have little insurance, not a lot of money. What do
Right.
you tell people to do? How do they get medical care when they don't have good insurance? They don't have a lot of money. Many times they
Mhm.
go to the emergency room. Is there an answer for that? What do you tell people?
And I don't think there's a bright line answer to that, but I will say part of I'm glad I brought this up when I was going over my little bit of my bio and background. The nonprofit that I worked at was an exemplary type of nonprofit for this exact situation, because they were one of many. I didn't even realize how many actually existed at the time and still do, even though the one I worked for went out of business. But these essentially what we call free clinics. So the specific type of clinic I worked at was known as I'm going to blank on exactly what it is. I'm probably going to get this slightly wrong, but it was basically a federally funded health clinic. It had an acronym. I just don't remember if that's exactly what it is or not. But essentially, it was designed for the exact purpose of people in this type of situation, and not just people that are going for disability and need to maintain regular medical treatment to prove their disability, but there are clinics out there, including ones like, and the one I worked for was one of the rare gems in that you weren't just getting simple primary care type of in and out, just making sure you're stable and that you're okay. I mean, this was a place that not only had multiple locations throughout Baltimore City and even some areas outside the city, it was providing specialist services, not just primary care. It was providing, I think we had a neurologist on staff. We had a couple of OBGYNs on staff. We had, I want to say we had a nutritionist perhaps.
Okay.
And a bunch of other ones too. Again, not worth going into all that here, but people could actually get quality healthcare. This was a company that actually believed in the whole principle of healthcare is a right, not a privilege. That was their motto, and it's such true words. I mean, there's no two ways about that. And I am now at the forefront when I have clients that are in that situation, and I'll find out from the get-go. One of the first questions I'll ask after my main 4 questions is, I'll actually kind of ask it in a way that I'm assuming. Maybe I shouldn't do that sometimes, but usually it doesn't yield any surprises. I'll say to my prospective client, I assume you are under the care of 1 or more doctors for your conditions. And 99% of the time they say yes, but the 1% where somebody says, well, right now I can't afford it because I don't have money or insurance and I'm out of work. That's when I'll start getting on the horn and figuring out where they live and what's near them, because these types of clinics really are dispersed all throughout the country. It's not just one little pocket somewhere that if you don't live within a certain mile radius of it, you're never going to be able to get there. And many of them even have transportation services available that you're not going to pay for. And again, if you have no insurance and no income, they'll do sliding scales, or they'll see you for free. And at least you can just get in there, if for no other reason than for palliative care, and just to establish your impairment's still present and it's still as severe.
Yeah, no, I think you make a very good point. You have to really look for these places. They do exist. Look, there's MRI clinics. I'm in Atlanta. You can go for $350, $400 and get a lumbar MRI.
Right.
Well, that can make a huge difference in a case. So
absolutely.
Yeah, but I think that the only caveat I'd offer folks is these places do exist, but you got to look for them.
Oh yes,
And
you can find them online. I mean, more and more of them do have an online presence than they did even back 10, 15 years ago when I was first working at this place. They had a website and they had been around for a while, but they're not well advertised. You do have to look, but they're there.
What do you tell clients? Because I have people ask me, I want to try to work part-time, and of course we both know that SGA or substantial gainful activity is $1,620 in 2025.
Yep.
What do you tell people? Is it a good idea to work part-time? Should you keep it below? I always tell people, you don't want to go to, if it's 1620, you don't want to go, you don't want to be $1,619 a month. You might want to keep around $1,400-$1,500. What's your take on somebody says to you, Andrew, is it okay to work part-time? What's your response?
So, first of all, as a human being, they come to me, I'm an attorney, but I'm also a fellow human being, and I get what it's like. I'm not saying that I've ever struggled in a way that I know a lot of my clients do, being out of work because of their medical conditions. So if a client comes to me and is more or less, because the most frequent occurrence of this is somebody that says, I need to try to do something to bring some money in because I can't survive otherwise. SNAP and TDAP benefits pay pennies. That just doesn't cover what it needs to cover. So one of the things I'll tell them right off the bat is I will make sure that they understand there is absolutely no guilt and shame, at least come in my direction, that if they need to do that, I get it. I understand. Now, on the flip side, of course, I do have to go through my usual litany of explaining how that could potentially impact their claims, starting, of course, like you just said, with how much you're earning from whatever before I even get into what are you going to be doing and how often are you going to be doing it. Let's start with, can you guarantee your earnings are going to stay below the SGA level, which is currently $1,620 a month, and it's not that difficult to pass it, even if you're earning minimum wage. It all
that's $19,000 a year. We're not talking about
exactly.
Money. Yeah.
So, if I get past that threshold, then I start getting into, okay, well, what exactly is the work? How many hours a week, and what are you going to be doing? So, one of the things that I have to be very upfront with my clients about and kind of caution them on is whatever you're going to choose to do, it needs to align with what you're claiming is the reason you're disabled. In other words, if you're saying you're disabled primarily because of physical impairments, especially for my older clients that are trying to, satisfy a grid rule,
Right.
if you go out and start doing a level of work, even on a part-time basis, where you're still doing something that's somewhat physically demanding,
Right.
you're going to have a potential problem, not only satisfying the grid, but just on credibility reasons and in general. You're going to have a really, really hard time selling Social Security that you're as bad off as you seem if you're even going out doing this part-time. And I've had some recent cases where even some of the ones I've won, and I just had a partially favorable case that was awarded on the grids. And I highly suspect one of the reasons the judge did that is simply because my client is still working part-time, non-SGA work, and was doing it at the time of the hearing. We talked about it very openly, and he even mentioned where he gets a lot of accommodations that most employers won't give. He gets extra breaks. He's had to call out when he's not doing well and this and that. But I think it still hurt his credibility enough that the judge would not be willing to either A, give him a sedentary RFC, or B, find that he's going to be, if this was full-time work instead of part-time, that he would be sufficiently off task or absent significant that he wouldn't be employable. And those are the kind of considerations that have to be made. But the end point of every one of these discussions is very simple. If I tell my clients, if you want to do this and you feel you can, I am fully behind you on it. I encourage you 100%. And if you even do well enough with it that you think you could work more, even if it means you're going to cross over the SGA threshold, I absolutely have no issue with that, even if it means we may have to consider whether we can proceed with your claim further. And I'd rather know that early on. I don't want that to creep up on me, especially if I have a client that just didn't bother to be fully candid with me about it. And then suddenly, when I don't have access to their earnings record, we get to the hearing stage a year or two later.
By the way,
all these earnings, I'm like, oh, okay. Would have been nice to know that 2 years ago. So,
and you can also, by the way, you can do a closed period in some of those situations. If you're out for a year.
Yes, and I've done that successfully as well. So that's always on the table, just the same.
And let me just add one thing, and you made me think of this as you're talking. As a claimant, this is your life, you're living this, and you're talking about getting accommodations or special considerations. You call out when you need to. This may be absolutely 100% true. Judges are real cynical. So you get in front of a judge and you say, well, Judge, I'm supposed to be lifting 40 or 50 pounds, but my coworkers help me. I only really lift 10 or 15. Judge may not believe you.
Right.
And so you may be telling the complete truth, but judges have heard a lot and they get real cynical over time. So, even if you're telling the truth, one of the things you might even, what I would tell somebody to do in that situation, get a coworker to write a statement, basically describing those accommodations and talking about the limitations you're having, because just because you say it doesn't mean the judge is going to buy it.
Absolutely.
Right.
I
so
agree.
You got to be careful about that.
Absolutely.
All right. Let me a couple more questions. I know we got a bunch of things we got questions we have to answer, but I want to add a couple more things out of my list. Do's and don'ts. You're preparing your client for a hearing. Are there certain things you tell them you need to avoid doing this, or these are things you definitely want to do, just to make your chances at a hearing better? Just some practical tips from what you do.
So what I think probably my most popular viewed video on the YouTube channel, which I think was the second one I made after the very first one, was my hearing prep video. It's about an hour long, and it walks through the whole entire process of the hearing from start to finish. And what I typically do is I have my clients watch the video ahead of time. I'll send them the link to it way ahead of time, and watch it as many times as you need to, break it up as you need to. And then the day before the hearing is where we do our comprehensive prep call to basically pick apart and highlight the most important aspects of what's in the video as to what you should and shouldn't be doing during the hearing. So the main thing that I highlight as a do is the most important line of questioning that my client's going to get, whether it's from me or from the judge or both, are the questions concerning the symptoms and limitations. That's what truly makes or breaks the claim, no matter what. Whether we're arguing a listing or grid, it doesn't matter. We still need to get into the details of what kinds of symptoms and limitations do you experience every day as a result of your impairments, and how does that translate into an inability to work? And to just simply make broad and general comments like my back hurts, I can't stand long, I have to constantly shift in my chair, I have to rest, during the day. That's all well and good, but that doesn't really paint the clear picture for the judge. That doesn't tell the judge how you as Joe claimant really are experiencing what you're experiencing. So I'm trying to encourage my clients, get in there with as many details from your own life as you can. Tell the judge in specific examples, as often as you can give them, what you're experiencing. Tell them not just that I can't stand long. Tell them, first of all, quantify it if you can.
Right.
I can't
Quantify
stand more than a few minutes. If I'm trying to stand at the sink to wash a couple dishes or bend to put them in the dishwasher, the minute I go to do that, I'm going to be in excruciating pain, and I've got to immediately go sit down, rest. I got to elevate my legs. I may have to take pain medicine. I may have to sit on a heating pad. That kind of answer in that example is one that is just so much night and day different than just simply saying, I can't stand longer, my back hurts.
Yeah.
And it really does, like I said, paint such a clearer picture for the judge. So it's kind of both it illustrates both a do and a don't. The don't part of it is just don't be too brief or too vague in your responses when we're talking about that aspect of the whole claim. We want to really get to the whole idea of what does your daily life look like, that if you were employed by some employer doing an 8-hour day, 5-day-a-week job, why you would not be able to consistently perform that. What would make you have to be off task when you're at the job? What would make you have to leave early, come in late, call out sick, et cetera, et cetera. And that's where we really need to hammer it home with the judge to make sure that they are left without a shadow of a doubt. This is somebody that a prospective employer will not hire or will not keep on if they do hire, and then they get to see how they really operate in the workforce. So,
yeah, I agree. I think you said this before. You have to quantify. I'll be talking to clients in pre-hearing, and I can't sit very long. I'm like, eliminate that from your vocabulary. Not very long, not very much, not long at all. Can't talk that way, because the judge is going to take your testimony and very likely put it into a question for the vocational witness, where it's very, very specific. So the more specific you got to, and I'm going to throw one more thing that I would tell people is, you always want to have an attitude that you're a fighter. You never go with the idea, I'm eligible for disability, I know it, I've given up, pay me. You go with the idea, I hate the idea of being here, I find it demeaning. My life is, I feel like I'm not less of a person.
Right.
I'd much rather be working. And as soon as I feel better, I'm going to be back at work. But I'm a fighter every step of the way. And I think judges I call it an attitude of entitlement. You never want to have that. It's really, really important.
Absolutely.
To demonstrate that.
Fully agree with that.
Yeah.
And I'll tell you too, just to quickly piggyback off that, one of the most common misconceptions that a lot of clients that I've come across over the years have when they first come to me, and I don't necessarily view this as an entitlement. I just view this as they don't fully understand what's required to prove disability. So I'll have a client that comes to me that, usually I'd say someone in their 50s at least, that's pretty much done one line of work their whole entire life and career. And for many of them, it's a very physically demanding type of work. And when they say to me, I can't do that work anymore, so of course I'm disabled, right? I'm like, well, not necessarily. Just because you can't do that work doesn't mean that they can't find something else for you to do. Well, what do they expect me to do? It's like, that's the point.
Yeah.
It's not so much what they expect you to do. It's about what are you potentially capable of doing, and is there enough of it out there that exists, assuming there's no grid rule that would take that out of the equation.
Oh, that doesn't mean there's a job around the corner. It just means potentially there's something out there.
So I have to tell that's probably as close as I get to the concept of entitlement with any clients, to say, because a lot of times it'll be followed by something along the lines of, I paid this money into the system all these years. Aren't I entitled to just get it back now? I'm like, well, you would think that, but just like any insurance policy, that's just not the way this.
They don't see it as your money. And I tell them, I say, look, Social Security sees it as their money.
Exactly.
They're not going to give it to you unless you prove that you are disabled, and you have to go with that. You can't go in and say, "Hey, judge, I paid in. I want my
Yep.
money out." That does not resonate with judges at all.
Exactly.
All right. You mentioned before that you do speak a lot. I see you, frequently speaking on CLEs
Yes.
and NOSCR and so forth.
Mhm.
Any sense of any big changes coming down the pike over the next year, 6 months, year, 2 years? We obviously, do not have a current administration that's particularly, open to Social Security disability. We
Yes.
had a really good commissioner, before the end of 2024.
Right.
We have a new commissioner. Nobody really kind of knows what he's all about, but any sense of what we can expect going in the next year or two?
Well, it definitely seems like the trends. So when I first started practicing 20 years ago, the pendulum seemed to be more this way, which was more, for lack of a better describe it, was more on the pro claimant side. Like
Mhm.
everything seemed to favor the claimant. And over time, it's definitely swung a lot more this way, like pro agency, and a lot less tendencies to be as quote unquote generous. Now, there was a period of time where it seemed like the pendulum was sort of swinging back pretty close to being level, where it was truly kind of a 50-50 type of,
Mhm.
um, some claims could easily go one way that you would expect them to. Other claims would go the other way, and it was kind of happening on both sides. Claims that were kind of borderline that I thought were more likely to be denied were getting approved, and vice versa.
Mhm.
Um, Definitely one of the big trends I've seen, and I don't know how much you've perhaps addressed this in prior live streams. The advent of 24.3p, which is the newer Social Security ruling that came out last year, that makes the work of the vocational experts less burdensome for them and for the judges, and more burdensome for us as the attorneys, trying to combat what they're coming up with as far as the jobs, the job titles, the job numbers, the reliance on the Dictionary of Occupational Titles as opposed to some of the other publications, and all this and that. It's creating a much more difficult minefield for us to navigate, and to try to raise these issues on appeal beyond the hearing stage. They're making it a lot more of an uphill battle for us. I don't know how much worse things potentially can get from where they are now. I've certainly run into my fair share of issues with that. Um, it also just, it seems like there's a lot more difficult. I touched on this a little bit earlier. It seems like there's a lot more difficulty as far as getting just clean. I don't want to say that claims are being overlooked. I just don't think they're being as thoroughly reviewed and evaluated at the initial and recon levels as they used to be. It almost feels like somewhere behind the scenes, they're being told they have to meet a quota of denials.
Mm.
That wouldn't surprise me if that's really what's going on. I'll never know for sure. And when I see cases that I know for a fact should in no way be denied, and then end up getting denied once or twice, that's the only logical conclusion I can come up with, is that it just got caught up in that. The other thing to point out real fast as well is, and I don't remember who really brought this to light for me. I mean, it's not something I didn't know was happening, but I never really truly put two and two together. Again, for anyone on here that isn't already familiar with this, there was Apple TV did a 4-part documentary about this true story about this former Social Security attorney named Eric Kahn,
Oh yeah.
who, ironically, with that last name,
Right.
boy, is that a fitting thing.
Yep.
He perpetuated such a tremendous years-long fraud that there was at least one ALJ and some
Yep.
medical professionals in on it with him, that they were basically conspiring and just banding together to create profiles of claimants that were not necessarily true profiles, to get them approved, to rake in buku bucks. I mean, we're
Mhm.
talking about, I think at one point the estimate was this guy probably pocketed somewhere in the neighborhood of $1 billion over a period of years
Wow.
in fees, that he was giving kickbacks to this judge and these medical professionals. They all got caught, went to prison, or that one of them, I think, is passed. I think it may even
Yeah,
have a suicide.
the judge died. I think Eric
Right.
actually cut his monitor off, and he was on the run for a while.
Right.
So
So the point in bringing that up is just simply that when that happened, that was somewhere around the mid 2010s.
yeah, they overreact.
It was a huge news story. Well, huge for us, probably not as much on a national scale until the Apple documentary came out. But the point is, ever since that happened, that's where it seems like the pendulum has swung a bit further this way,
Right.
where so many more good claims are getting caught up in the net, so to speak, of casting that wider net to make sure fraudulent claims aren't getting through the system. And I don't candidly believe, with that example aside, and that's more of an outlier, that's more the exception than the rule, because us attorneys that get into doing this, we get into it for legitimate reasons, and we are legitimately advocating for our clients. We know that if there is fraud that's occurring out there, it's probably so marginal and so randomized that we are not the ones that are helping perpetuate that. The people that are doing it are true, again, forgive the pun, con artists.
Yeah.
And our clients shouldn't have to be paying the price for that. But I don't think the government, at the moment at least, knows a better way to do it. And I think that's a big reason why the trend has gone in that direction, because they figure that's the easier solution to this. Just cast that wider net. And, the ones that truly want it and think they deserve it will keep fighting, or at least their attorneys will keep fighting for them. But some of the fights we have to fight, I mean, just feel like it's grasping at straws in a way we shouldn't have to be.
Yep. I think the Eric Kahn debacle really was an overreaction, particularly the elimination of the treating source rule.
Absolutely.
The ridiculous, and for those who don't know what I'm talking about, used to be the rule was if you had been treating with a doctor, consistently, that doctor's report would be given controlling weight.
Right.
And they eliminated that. So literally a judge can look at a non-examining doctor's evaluation of your medical record and deny a case based on that. I don't think most judges do it.
Right.
I've seen a few that will, and certainly at the initial and recon stage they'll do it. But it eliminated, you obviously a doctor who's seen you for 3-4 years is in a much better position to evaluate your disability than somebody who saw you once for 30 minutes. But that's what it is. So, all right, let's go into some questions here, because we do have a bunch of them here. SA is one of my regulars here, and SA says, been looking at comments. Do you think being able to walk a third, 0.3 of a mile, not even, I guess it's close to a third, in an advanced age back case is too far? And what about 2 blocks? Not sure about the yards on 2 blocks. Somebody told me that they were scheduled, a call by SSA and discussion about his life and health, 30 plus minutes were scheduled. Let's actually go to the first question. So I have my answer, but I want to see what you say about this. Being able to walk, let's say a third of a mile,
right?
Is that too much?
So one comment about that, because it's interesting and it's a tricky line to walk, no pun intended, because one of the things I'll tell my clients, and this usually comes up more so in terms of filling out forms like the function report, is that when they're giving a specific measurement or quantity, whether it's time or distance, I always tell them, I don't want you giving a specific quantity or measurement unless you actually have timed it out or measured it. So if I have a client that thinks they can walk a half a mile, but they haven't actually measured out the fact that they can, they're potentially putting themselves in a bad spot to estimate that without knowing it for sure. Now, that being the case, when we're talking about in the context of going before a judge with that kind of testimony, part of it's going to honestly depend on the judge. I mean, there are some judges that are not going to be that receptive to what that measurement might actually look like. And there are other judges that are going to dissect the heck out of it and really pick it apart. But the key factor for me in something like that is not so much the distance or time that a person says they can walk or stand or whatever it is. It's, are you saying you can do that once during the day and then you're out and you have to rest the whole rest of the time? Or are you saying that repeatedly throughout the day you can walk a third of a mile, or you can be on your feet for 30 minutes or more? Because it's the latter of those two that's potentially where you're going to see that's going to be your potential difference maker. Because if you're saying that you can consistently throughout, and like theoretically an 8-hour workday, you can walk a third of a mile at a time, quantitatively speaking, that's probably going to equate to a level of standing and walking that equals at minimum the light RFC level, potentially even the medium RFC level. And that if you're talking about a case, because I think I overheard you saying the question that this person's asking about an advanced age person, that could potentially take you out of the possibility of a grid approval. And then you kind of shot yourself in the foot by coming out with that, even if it's technically true. And I would never encourage a client to be anything less than 100% truthful, but there is such a thing in my view as oversharing sometimes too.
Yeah.
And
I think especially men,
right,
we tend to
the macho
over,
attitude,
right. You think about how you were. I mean,
Mhm.
you think about, okay, when I was 28, I could do this. Well, now
Right,
I'm 57, I can still do it. And you really can't. So you have to,
right,
I always tell people, I say, look, when you're talking about what you can do, think about it not on your best day, not on your worst,
Mhm.
maybe on a scale of 1 to 10, a
Right,
4, right? A slightly below average day. And I think your point very well taken. Can you
Mhm.
do it once? Can you do it, 3, 4 times? Can you do it
Right,
8 or 9 times? Makes a huge difference. And you got to,
right,
they're not going to assume anything. You got to tell them. You got to tell them you
exactly.
do it once. And so I think that, you know, being able to walk a third of a mile one time and then you got to rest all day is totally different than doing it 5, 6 times. So you just got
Absolutely.
to be careful. Okay. Essay, second question. Somebody told me they were called by Social Security and question about life and health for 30 minutes, then scheduled for 2 CEs. They were approved at initial. Are these phone calls common? So it looks like this person got a
Mhm.
phone call from the adjudicator who asked a lot of background questions. Is this common?
So if we're talking, when we say adjudicator, if we're talking about the DDS caseworker,
Yeah.
it is common, particularly if it's somebody that's not represented. Now, this is kind of a butting heads issue that I've been dealing with over the last, I'd say, year or so. And I'm finding it coming up more and more than it should be. The standing rule is that when you have an attorney representing you at any of the initial or reconsideration levels at any point in time, and DDS knows it because your 1696 appointment of representative form is in the file, so they see it. The rule is they are required to contact the attorney initially and get permission from the attorney to speak directly to their client. And if they don't get that permission directly from the attorney, they are not permitted to do that. Now, some of these caseworkers don't seem to want to follow that rule for one reason or another, whether it's just they're not familiar with the rule, they're being lazy about it, they're trying to put one past. And I've seen some of these caseworkers run afoul of that to the point that they not only call my clients directly behind my back, knowing, and in many instances, I've specifically instructed them, do not call my clients. You come through me, mainly because I don't want to stress my clients out. This is
Mhm.
stressful enough for them. That's what they hired me for. But also, I'll find out that they started not grilling, but asking questions that clearly were grilling type questions. My clients didn't know any better, and they thought they were required to answer it, and ended up stating things and admitting things that ended up being used against them and ultimately leading to a denial, all because this caseworker did what they weren't supposed to do. Now, in this particular example, it sounds like it went the opposite way, and that's probably, in my experience, more the exception than the rule.
Mhm.
But um, to answer the question in general, the caseworkers do reach out and ask these types of questions, but if there's an attorney involved, the question is supposed to go through the attorney unless the attorney gives explicit consent to say, yes, you can speak to my client and you can get that information directly from my client. So,
Yep.
yeah, it does happen.
I would agree. And again, this is just another situation where you want to have the counsel of an attorney to discuss how to
Right.
best answer those questions and how to quantify. Because again, I'll talk to people and first question, how long do you think you can walk? Oh, about 2 miles.
Hmm.
As you said, when's the last time you walked 2 miles? Well,
Right.
and then when you
Exactly.
when you talk about that way, it's really probably only about 4 or 5 city blocks or
Right.
maybe a quarter of a mile. Big difference, and it can make
Absolutely.
a huge difference. All right, JTLBZ, and this is so we talked about this a little bit before.
Hmm.
They could change the eligibility. What I've heard from a couple places, although it's very spotty at this point, there's some talk about changing the grid rules to basically move them up 5 years.
Mhm.
I don't know if you've heard that or not, but I've seen two places where there's some talk that they're going to try to make, the grid rule start at 55 as opposed to
Mhm.
50, and then it'll be 55 to 60, then 60 to 65 or whatever. Again, I haven't seen anything formal,
Yeah,
but
I haven't either, but I will say this. I do want to mention this because I've brought this up to different people at different times, including some judges, some caseworkers, etc. The grid rules are good when they work the way they're intended to, but they are also very flawed. And I don't think it would be beyond the realm of possibility that they could do for some overhaul and a little bit of revamping. And here's the prime example of where I think they could use some overhaul. So regardless of the age brackets that we're talking about, and regardless of the RFCs and all this and that.
and by the way,
One,
I just want to make sure people understand when you say RFC, that
oh
stands for
yes, sorry,
residual functional
thank you.
capacity. That
Yes,
is what your capacity is, residuals left over after we factor in your medical issues. So
right, right.
that's
So it could be
that's
a
a legal determination judge is making about what your
right,
capacity is. So just to
exactly.
okay.
Yes, thank you, thank you.
No, no, it's okay.
So the prime example, and you and I actually sort of discussed this a little bit earlier, is a situation where somebody crosses into a new age category somewhere during the pendency of their claim. So when the claim started, they were in one age category, but at some point later on, they ended up in a different one. And because once they enter that age category with the RFC they have assigned, suddenly they're going to satisfy that grid rule and be approved as of that age. Here's the part of it that never made true sense to me and why it can't be decided in a vacuum, in my opinion. Because to say that somebody, so let's say it's somebody crossing from age 54 to 55, they have a light RFC throughout, yet at 55 that's going to grid them out, whereas at 54 and younger it won't. You're telling me that when this person is 54 and 364 days old, they can get hired doing a job at the light exertion level,
Right.
but the minute they turn 55 even, suddenly an employer is not going to hire them. How does that logically make any sense? And same thing with turning from 49 to 50. So at 49 and sedentary, unskilled, you can work some kind of work, but once you turn age 50, nope, all bets are off. Employers aren't going to hire you. It's those type of situations. I mean, we have the borderline age rules where you can
Right.
advance somebody if they're close to the next age bracket that'll get them to disability. But that's one of the main areas where I think these grid rules are extremely flawed. And I would be one of the first ones in line to advocate for some type of change to say, they shouldn't always be applied as rigidly and mechanically as they seem to be, because it's allowing too many liberties where Social Security make decisions and determinations that just don't follow any logic. And we know that's one of the prime requirements from any decision maker is you must build that logical bridge from the medical evidence to the findings and conclusions you make. And that's just one that I don't see how you make that leap.
Although I
That's
will
just
say,
me.
one thing I find very interesting, like will make a grid rule argument. Everybody if they're physical over 55,
Mhm.
and let's say the judge approves it, which was obviously what we want to have happen. The decisions are always written where the judge will decide it on a functional capacity theory and say,
Right.
however, even if the person's capacity is this, the grid rule would also dictate a finding of disability. So it's almost like they don't use the grid rule as the primary reason to approve.
Mhm.
It's kind of a secondary reason.
Right.
So I always thought that was kind of interesting why
Right.
judges do that. I'm not sure exactly. Not all do, but that's just
The good ones do. Yeah.
yeah, yeah. But but I think your point is well taken. Is that
Yeah.
the grid rules can be rigidly applied, and that doesn't always make a lot of sense. And quite frankly, a person who's 48, with significant problems, is not that much different in terms of their
Right.
hireability from someone who's 51.
Exactly.
But one meets the grid, one doesn't.
Right.
Okay. Tara Upshaw is one of my clients who just had a birthday, by the way. So
Happy birthday.
Tara, happy birthday. Good to see you here. Although I think she thought she was here at 7:13 Eastern, so hope she's
Okay.
still here. Sarah D. Okay, this is an interesting question. I'm going to phrase it a little differently, but I have my ALJ hearing next week and haven't seen what the judge assigned. Looks like it's Helen Valkovich. I don't know. Does she have good approval ratings? I haven't heard from my attorney. Should I reach out to the hearings October 20th? There are many places that one can go to look up judges' approval ratings. Do
Yes.
you recommend that your clients do that or not?
Well, I don't think I could stop it if they wanted to.
Right.
I fortunately, I don't think many of my clients do know this. I'll let the cat out of the bag. It's not a secret or anything, but there is a section of the Social Security website itself. This is not a private website. There is a separate one that I don't even know if it's still technically being monitored, but there is a section of the Social Security website where you can not only look up the statistical approval and denial rates of each current judge on the bench everywhere across the country, but you can even look at archived data files to see what their approval rates were in previous fiscal years. So they go from I believe the fiscal year is October 1st to September 30th. So that's where it's based off of. So as an attorney, especially nowadays, we're doing everything remotely. So I personally, and I'm sure Jonathan, you do the same thing, where you're still probably primarily taking on claimants that are in your geographic region, but also now able to take on clients in other areas of the country. And sometimes it's not even about that. We have local clients whose claims, because their hearings are being done remotely, are getting reassigned to other hearing offices in the country.
Right.
And that puts us in a situation where suddenly we're going before a judge we have no familiarity with. Now, we do have the NASCAR listserv where we can, like you said, we bounce these off each other all the time, and we usually get some pretty good feedback and responses. But at minimum, I'm always going to go on that website to get an idea of whatever judge I'm assigned to, if it's someone I don't know. And sometimes even for judges I do know, I want to see what their numbers are now versus what I knew them to be previously. And I want to look at their approval versus denial ratings, primarily because I want to get a sense of, the numbers mean what they mean. You've got some judges that teeter somewhere between 40 and 50% approval. Some are higher, some are lower. But usually what that's going to tell me is if I have somebody that's at least somewhere middle line or higher, that's going to tell me two things. Number one, that it's likely a judge that is going to have a good bedside manner and not make my client feel like they are the scum of the earth for filing for disability, and they're going to put them on the spot and make them feel so low, because there are sadly judges out there that will do that act very condescending towards our clients and us as well. And two, it's going to tell me, is this a judge that's going to be fair and reasonable and come into my hearing with an open mind? Or is this a judge that's going to come in more than likely with their mind completely made up? They have a preconceived notion of exactly what they're going to do. They're holding the hearing because they're required to, but their minds are already made up. And those judges are also typically the ones that the minute the hearing's over, I go check the status online on ARS, Appointed Rep Services website, and suddenly the case is in decision writing the very next day. I mean, if that isn't a clear sign this judge already knew what they were going to do before the case happened or the hearing happened, I don't know what is. So that's typically what I use that website for. And I'm very upfront with my clients about that. If they haven't seen it themselves, I'll say, look, we're going before Judge so-and-so. I looked them up online. It looks like they're approving about 60% of their cases. So that's certainly higher than the national average, and that's pretty good. That's not a guarantee of anything. I could find a judge that approves 90%, and it's not a guarantee of anything. But it's hopefully going to tell me that this is a judge that's going to have an open mind. And that's the most I can ask for any client of mine going forward. And that's what I always hope for.
Yeah, no, when I just to answer this particular question, this is, and I just pulled up on this, so I'm going to show this. This is one of the websites used, and this particular judge has let me move this down. 59% looks great. Fully favorable, 41%, partially favorable, 18%. That says to me that this judge approves cases but changes the onset date.
Yes.
That's what's said.
Yes. That's something I forgot to mention on that Social Security website, where it has also the further breakdown of how many of the approvals are fully versus partially favorable. Absolutely. If you're seeing a much higher incidence of partially favorables, you've got somebody that is either changing or offering the change of the onset before the hearing even occurs.
Yeah, it
That
doesn't
is
mean
the
it's
deal.
going to happen, but that just
Right.
means if you're 54, there's a decent chance that you're going to
Mhm.
get the judge will say at the
Right.
hearing, counselor, have you considered changing the onset date to the 50th birthday? And
Right.
that's something you want to talk to your client about ahead of time. Let them know that's coming and
Yep.
say either yay or nay. And I'll tell you, sometimes I've talked to my client, will say, no, we're not doing it.
Right.
And some judges will like, okay, and then they'll still, you got to stand up to them to some degree. And you
I had
want to have an argument.
I'll quickly share this tidbit. I
Mhm.
had that happen to me years ago on a case. My client did not want to accept the amended onset date, and the judge ended up denying the claim
Mm.
altogether. And it was a grid case. So we not only appealed it on that basis and several others, we ended up filing a complaint with the Division of Quality Services against the judge,
Mm.
and that judge got investigated and I believe removed from the bench. I don't know if it was specifically as a result of that,
Yeah.
but I said, what would have happened if my client agreed to amend the onset date voluntarily and then this judge denied the claim? I'm sure at the core, I would have been able to eventually undo that action because of the false pretenses this judge
Right.
offered it on. But that could have potentially put him in a really precarious position if he had agreed to that.
Yeah.
So yeah, you're absolutely right. We have to fight like hell for our clients and stuff like that. And it happens if it happens one time, that's one time too many.
Yep. Yep. And Sarah also says her hearing is October 20th. Have not heard from your attorney. Again, the attorney may still be working to get the file put together. I don't like to ever second guess another attorney because, again,
Right. Me too.
until the hearing office puts the files and the numbers are done, the attorney may be not able to really tell you very much. And look, this is a practice area. And Andrew, you and I talked to this before we went on. This is not something where you're making, tens of thousands of dollars in a case. You've got to
Right.
really watch your time.
Right.
So, when people call me up and you're doing this as a solo and I've got staff, but when people call, what's the status of my case? A lot of times the answer is nothing because the Social Security is taking a really long time.
Right.
So I'm not sure that I would say that October 29th, there's really much that the attorney can tell you. Certainly you want to let the attorney know that you're waiting for the call and to please let me know as soon as the file's worked up, you've done your pre-hearing work. But I don't think that inherently means anything negative. That's still pretty far out.
And my take on that, just from my perspective, one thing I tell every one of my clients from day one, and a lot of times I have to reiterate this either because they forget or just, they get anxious, and I understand that. This is their livelihood more so than it's mine. I will always take a call from a client, return a call, return an email, and I'm usually really prompt about it. That's one of my big pet peeves because I know what it feels like to be on the other end. So if somebody calls me, I'll typically, as long as I'm able to, I'll typically return the call the same day or return the email the same day. But what I also am very upfront with my clients about is I do not like to reach out to you at a regular interval if I do not have an actual update to provide you. I don't want to just reach out on my own to say nothing new, nothing changed, all still pending. If you ask me that, and that is what the update is, I'll tell you that's what it is. But I don't want my clients to kind of jump down my throat of, I haven't heard from you. Can you tell me what's going on? Well, the reason you haven't heard from me is because there is nothing going on and I don't have anything to go over with you. The minute there is a change, you will hear from me. But until then, I just don't have anything new to add. And it just doesn't make sense for me to proactively reach out just to say nothing's changed. It just logically doesn't make
There's only
sense.
so many hours in the day.
That
Do you
too.
ever tell your clients to contact their U.S. senators, U.S. representatives to do a congressional inquiry? I find that tends to move things along a little bit.
Yeah, if I've got a claim that's really stagnant, and I don't typically employ that unless the situation is it's an approved claim that's sitting and hasn't been paid out and it's been way too long. Now, what constitutes way too long may vary from one case to the next. Certainly, I have a breaking point of if it's been more than X amount of days or months and there's been absolutely no movement whatsoever, and I've been putting in calls to the field office, I've been trying to get through to someone at a payment center. Yeah, that's typically when I'm going to tell my client to initiate that part of the process, and I'll support them every which way I can. But yeah, I mean, it's a useful tool when you use it the right way. I mean, just to say, my claim is not being decided quick enough, or, I've even had a client or two that'll actually reach out to a congressperson or senator because they got denied and they think they shouldn't have. I'm like, well, they can't help you with that. They're not going to be able to come in and get Social Security to change their mind. They're just going to get them to move a little faster, potentially.
Yeah.
So.
And also, of course, if you're 100% VA disabled, that'll get you a different line as well.
Right. Exactly.
All right. Now, Sarah has a couple more questions.
Mm-hmm.
I have a few working diagnoses. What happens if I don't have a full diagnosis by the time of my hearing? I'm seeing specialists up to the hearing date. Thank you. And again, thank you, Sarah, for your participation. So what Sarah's asking is, she's getting ongoing treatment. It sounds like the doctors are struggling to find a specific diagnosis. Sometimes there can be a pain condition that could be, or there may be an organ issue and the labs are not definitive, or that it may need to be some sort of a diagnostic procedure. What do you tell people to do? They have a hearing coming up, but the diagnosis has not really been firmed up.
Right.
What would you tell them to do?
And it's funny that this comes up because I think it was last week, as a matter of fact, I had a new potential client reach out to me in that exact vein. That's exactly, and in fact, several other attorneys turned her away just for that reason, which was surprising to me, because I don't think that's, in my view, at least, a definitive reason that you should turn somebody away. It is, of course, nice to have something that fits into a nice, good, perfect mold of a diagnosis that has been around, is established by the AMA, we're all familiar with. It doesn't always happen that way, whether it's because they just can't figure out what the diagnosis is, or whether it's something they have not come across. This is something, I mean, every new diagnosis, or every diagnosis at some point was a new diagnosis at some point. Not everything existed from day one. The fields of medicine and science had to find a lot of these. So, one of the good things about the way the Social Security regulations are written is that it doesn't necessarily require you to have a definitive diagnosis that fits one of those molds necessarily, if you're documented in what kinds of problems and symptoms and limitations you're having that sound like some kind of thing that is, to start with, a working diagnosis and might turn into something else eventually. And it's, again, the key thing is that it's documented by your medical providers and doctors. That's really the most important aspect of it. And on top of that, you're demonstrating to your judge or whoever the decision maker is, depending on what level your claim is at, that you're not ignoring what's going on. You're taking proactive steps to get out to your doctor, to go to wherever they're referring you to for testing, or to see specialists, or to get lab work, whatever it is, to try to figure out what's going on. But you yourself know something's not right, and this is causing me problems in my everyday life that are leading to, or at least contributing in some way to, my inability to work. And because of that, that's why I'm not just sitting at home saying, oh, well, they can't figure out, I guess I'll just have to live with it and live my life the best I can. That's a completely different type of situation. And as long as you have that in your hip pocket, you can say, I've gone to the doctor, I'm not the doctor. That's why I'm going to them, and I'm trying to get this figured out. I've got something to work with. And as long as you have a halfway fair and reasonable decision maker, they're not going to hold it against you that your doctors haven't come up with a definitive diagnosis yet, because eventually they are going to figure out what it is one way or the other. And until they do, they're documenting what you're dealing with and how it's affecting you daily. And
so what you're saying really is that as long as your symptoms are consistent, the doctor accepts that you're being believable and credible, and perhaps has some sort of a working diagnosis, that's okay. Although I would still think that, the firmer your diagnosis, the better. I mean, that's
no question about that. I mean,
it's not absolutely necessary, but
the
firmer the better.
I mean, you and I certainly have seen our share of, over the years, diagnoses that are more readily accepted now, although we still deal with our some of our issues. A good example of that would be the fibromyalgia diagnosis that we still are fighting fighting tooth and nail. Even to a certain degree, mental health in general. I mean, it was probably not even 10 years ago that it still felt like you were constantly fighting an uphill battle if you had a client that just had mental health impairments, because they did not get the credence and credibility then that they do now. And you still have to fight pretty hard for them, but more and more people are recognizing how legitimate they are. And these are diagnoses that have been around for years. I mean, it's not like these are new diagnoses, but yeah, no, it's there's definitely something to be said if you have a firm one.
Look, and I think that this is to some degree a reflection of the Eric Kahn problem, is that
absolutely,
anything subjective, it's really easy for people in Congress to say, well, they're approving too many people with subjective complaints. We demand objective evidence. And as you pointed out, not every condition has objective findings. I mean, it's great if you have an MRI, but you're not going to always have an MRI if it's a chronic pain or a fatigue or Lyme disease, or there's any number of things that don't have that.
Migraines typically don't show on MRIs either, unless there's an underlying cause like a tumor.
All right, Teresa Bond. I'd like to know if you can answer why SSA would say they're withholding a lot of my back pay due to overpayment of SSI, which I don't receive. I also applied for Medicaid, and they denied me, saying I'm receiving Medicaid through SSI, which I'm not receiving. All right, so it's going to be hard to kind of unpack without really seeing documents, but it sounds like maybe at some point there was Medicaid or SSI paid, maybe presumptively. I'm just guessing. And maybe they later on found out that your income or asset picture was not qualifying you for SSI. This is probably something where, and I'm just going to go on a limb with this, might be where you might want to have a congressperson, support staff take a look at this and sort of figure out the actual numbers, because Social Security doesn't do a very good job when they send letters to explain what they're doing.
Truer words were never spoken.
So
let me add one specific comment on that has been a recent experience of mine in one of my or actually in a few of my cases. So if this is a case for the person who asked this question, where when you applied for benefits, you applied for both SSI and SSDI, which a lot of people do without realizing the difference between the two, and realizing that in many instances, you can't collect both. You can only collect one or the other. The problem is because Social Security doesn't catch up quickly enough when you get approved, when you get medically approved, they start calculating the SSI first, only to then later on discover you shouldn't have been receiving SSI in the first place. Now, in some instances, and this could be the situation that's been described, if no SSI has been paid, but an SSI claim was filed, Social Security, the SSI benefits are paid by the field offices, whereas SSDI benefits are paid by the payment centers that are separate from the field offices. Now, they're supposed to work in conjunction with one another, and they are not always on the same page at the same time. And here's where this comes into play in my specific experience. I have had a few cases in the last, let's say, several months where I have a client that filed for SSI and SSDI. They definitely don't qualify for SSI because their SSDI is too high, or they have assets, or both. And what happened was, even though no SSI payments were paid out, the payment center could not and would not release their back pay of the SSDI until they received the specific form, and I believe it's called an E345 form from the field office, that basically just officially puts in writing to the payment center from the field office, we did not pay any SSI on this claim. There's no offset. Therefore, you can now release these benefits. And until the field office does that, the payment center's hands are tied. And I learned so much about this within the last year on the cases that this has come up on, that it drives me crazy, because it seems like it's such a quick and simple thing to do. And oftentimes I'll get a lot of back and forth between the field office and the payment center, assuming I can even get through to someone at the payment center. The payment center will claim that they've sent to the field office what they're supposed to. The field office will say, we have not received anything from the payment center. And nobody's actually saying one is lying and the other's lying, but that's basically what they're implying to me. And that's oftentimes what an issue like that comes down to. And I do agree a congressional inquiry may very well speed that process up and get everybody to sit up and take notice. But that could absolutely be what's happening in this specific situation, because it sounds very familiar.
No. And I just had a case right now, which, where they sent my client a letter, and the numbers were improperly calculated. They basically, she was eligible for benefits, in 2022, and because you're eligible for benefits is March of 2024. Where did that come from? It was just a mistake. And my client is going really angry about it. And then 2 days ago, we get an updated letter. Oh, here's the new numbers. So they make mistakes like this all the time.
They are as far from infallible as you can get. I've seen them change onset dates incorrectly, not changing an onset date based on medical, where they have actually just put the wrong onset date when their own internal documentation told them the right one. I had a case actually down your way in Georgia, got approved. They had the form SSA 823, which is a form that tells them which onset date to use. It had the correct onset date. Instead, they put an onset date that was 2 years later. They forced me to file a reconsideration on it that sat for a year and a half before they assigned it to someone at DDS. Once they assigned it, the DDS caseworker closed the file in 24 hours, making the correction because it was just that simple. Crazy. Drove me absolutely insane, but it cost them a year and a half worth of past due benefits.
It was got to do it. Got to do it. Vince, one of my clients, who told me about Moomer's ice cream in Michigan, which I appreciate because I was in Michigan for a wedding not too long ago. So Vince is here pretty much every week, but thank you for telling me about Moomer's ice cream because it was actually really, really good. Okay. Let's see here. We got about 30 more minutes here.
Yeah, sure.
So let's go ahead. Okay. Golfer Pro. Wife was approved at a hearing last week. That's great. Back problem, carpal tunnel arthritis, 59-year-old. Teacher, tough judge, not one question. Just said they were approving, I guess, grid rules, grateful. Yeah. Look, there's nothing better. And I think I can speak for you, Andrew. Nothing better than a hearing where you don't say anything. Where in fact, I had a case come up probably about a month and a half ago. One of the more difficult judges here in Atlanta, happened to be an Atlanta case. This guy will deny cases that should be approved. I get an on the record from him. I get a phone call from the hearing office. Judges going to approve your client on the record. I about fell off my chair. It does happen.
No question. That's one of my favorites. Another one of my favorites is when they ask one question of the vocational expert that the answer is no available work. Mr. Sindler, anything of the vocational expert? No, I'm good, Your Honor. That's one of my favorite occurrences.
Yeah, no, I've learned a long time ago. Don't snatch defeat from the jaws of victory.
You go.
Never want to say. Okay. Let's see. All the positive feedback got the denial. Yeah, I know. This is one of my clients as well. This is just, as Andrew said, they're going to deny cases they shouldn't deny. And this is obviously what happened. So we'll appeal it and we'll keep fighting it.
That's all we can do.
All you can do. Okay. Cynthia, contact my senator. They said they can only help if I'm homeless or close to it. I spoke with SS today. For me, the reconsideration is 300 days out. Okay. Well, first of all, I don't agree that they can only help if you're homeless.
Right.
I think that my experience is if you've been waiting for 5, 6, 7 months, that's enough. They can do a congressional inquiry.
Right.
So you might want to contact the other senator or a representative because that's not the case that they can only help you if you're homeless. That's ridiculous.
That sounded like a lazy way out answer for whoever did it.
Yep. Okay. So Cynthia, I would tell you, contact somebody else because that's not been my experience. That's wrong.
Right.
Okay. Jennifer. Hello, Jennifer. Now had 5 cervical surgeries. Now myelopathy, had emergency 3. Let's see if I got the rest of it here. I'm not seeing the rest of it here. But anyway, okay. So I would say this, Jennifer, just in general, and again, every case is different. You've had 5 surgeries. That generally means that the surgeries are not really working. And after you have a certain amount, you sort of hit that point where you hit diminishing returns. So I would say, generally speaking, that makes your case, and again, it depends on how old you are, but that says to me that there's probably a permanent type of problem, I would say. 5 cervical surgeries, neck surgeries, assuming you have the numbness and tingling in your arms, can't turn your neck, can't turn your head up or down or side to side. That's going to give you a pretty strong argument, I think.
Absolutely.
Okay. All right. Eunice, who's here a lot, 55 years old, suffered a herniated disc in the vertebra. He's a sailor. His work requires him to lift 50 pounds, cannot lift more than, we don't know. But I think last week you said you could lift maybe 30. And my point at that point was, to get to the grid rule category at light, you got to be 20 pounds or less. So, if you can lift 25 or 30 pounds on a fairly regular basis, it's not going to be grid rule. That's probably going to make it really hard to win on a functional capacity argument, because 30 pounds is a lot of weight. So,
Right.
you might want to really look into and test yourself to see how much you really can lift.
Right.
Okay. Maureen says, good evening, everybody. Fowd says, how long will the case take at federal court? Okay. Different question. How long do cases take at federal court typically?
Okay. So federal court, first of all, we haven't even touched on this at all. For those of you who are not familiar, federal court is the pretty much the last step in the appeals process. So you have initial reconsideration, hearing stage, the appeals council, which we also haven't really talked about, which is where you appeal after a hearing decision. And then from there, you go to federal court, which federal court has different levels too. There's the initial district court, the circuit courts, and then the Supreme Court is the high court of the land.
Right.
So for me personally, I've gone to district court many times. I've been doing federal court appeals. I think I started them in 2014. I didn't initially do federal court appeals when I first started, partly because most of my cases were getting approved at the time of the hearing, if not sooner. So it was not necessary to consider federal court, which was nice. So it's a long story I will not go into right now, but my path to the federal court world is as interesting as the path to doing Social Security in general, kind of born out of necessity. Now, I do federal court work myself here in Maryland and DC, where I'm licensed. One of the things with federal court is that it has to be filed in the jurisdiction where your client lives at the time. And if you're not individually licensed as an attorney in that federal court, you can't do it yourself. You have, unless you get a local attorney to sponsor you into that court. Right. So my experience has been, and it's been fairly consistent over the years. This is one of the areas where the time frame hasn't really changed even since the pandemic. The average amount of time for me from the time I file a federal court appeal until the time that I get a decision on it is somewhere in the realm of 8 to 12 months. Now, what can change that in some ways dramatically too, 8 to 12 months is the time frame if a case goes all the way through to a decision. And what I mean by that is there are instances where you can get what's known as a voluntary remand, which is where after you have filed an opening brief laying out all the arguments why you think the judge's decision was wrong and shouldn't stand, the attorney on behalf of Social Security, because they do have an attorney that defends them at federal court, unlike any of the other levels, can actually come to you and say, we've looked over what your arguments are and we think you'll probably prevail. So would you agree for us to voluntarily send the case back down for further proceedings, which usually includes another hearing, often with the same judge, sometimes with a different judge, depending. And if that happens, the time frame is even less. So in that instance, it could be 4 to 6 months. And then if I've put together a really well reasoned brief with good arguments that are supported by law and facts, then that's not an uncommon occurrence. Another interesting rumbling that I'm hearing these days, Jonathan, I don't know if you've been hearing this as well. I think some of our colleagues on the listserv have been mentioning this. The attorneys on behalf of Social Security, these attorneys with the offices of general counsel, are, because a lot of those offices, just like everyone else, are very short staffed. A lot of people have either been laid off or left. And because of that, they are even more overloaded and overwhelmed than they've been before, to the point that there's been a higher incidence of them offering voluntary remands because they just can't keep up with the demand of the work. They just don't have the capacity to do it. They don't have the bandwidth right now. I'm not saying that's ever a reason to take a case to federal court. You need to have merit before you do that. But that's typically been my experience with federal court. Generally speaking, 8 to 12 months on a case that goes all the way through to decision with both sides filing briefs. 4 to 6 months on a voluntary remand on average. Some are longer, some are shorter, but that's typical.
But the wheels of justice in this regard do move
Mhm.
quite slowly there. Okay.
Mhm.
All right. This is another question I see. Teresita says, so I hope I pronounced that correctly. Received a letter from SSA saying they found me medically disabled. Can I give a decision because they need to do my non-medical review? What does that mean? What is a non-medical review?
Okay, so this has come up actually recently in several of my cases as well. And it could actually mean a couple different things depending on the circumstances. If it is an SSI claim, SSI only, or there's an SSI component to it, SSI, as some of you may be familiar, supplemental security income, is a government paid benefit. It's not being paid what you paid into the system coming back to you. So it's considered basically like a welfare benefit. And because of that, they won't pay it to you, even if you're medically disabled, unless you can also demonstrate that you meet the financial requirements that you have to show, that you don't have more than a certain amount in what we call countable resources, any income or assets that they can count against you. So that could be one aspect of the quote non-medical review they have to do. On an SSDI claim, if it's a case that when I typically see that in an SSDI case is where they have proposed to amend the onset date. And if that's what's happened, what they're reviewing at that point is, number one, will there be any past due benefits available if they've changed the onset date so dramatically that there's no accrued past due amount to pay where there would have been had the original onset date stuck, or with SSDI benefits, which are basically like getting benefits paid under an insurance policy, they have to check if you're past the cutoff date, what we call the date last insured, which is the last time you were covered under SSDI based on when you stopped working and paying into the system. So if they're proposing a new onset date that's past that date last insured cutoff date, then that's what they're making the determination on. Can we pay you benefits on that basis? Because we've determined you didn't become disabled until after your cutoff date, so we can't pay you for that reason. So it could be any one of those things. It's also possible it's something else entirely without, more of a context. I don't know that I can speak to that.
I think the other thing it could be is, they want to make sure that they want to see if there's been any work at SGA level since the earnings were last reported, because
Right.
they don't get that information necessarily in real time. They get it when the IRS reports it to them, so they may have to ask questions about if they see any earnings, that sort of thing. And because if they show SGA level earnings that might take you out of the disability world before they're going to approve you, they need to make sure there's no SGA problem there. So that could be an issue as well. But yeah, it's a good sign that they approved you medically. But yeah, the other shoe about to drop? We don't know, but something to kind of watch out for. And sometimes they confirm that there's no SGA level earnings, you get paid, and everything is fine.
Yes.
Okay.
I don't like to go into it thinking the worst. I'm prepared for it, but I still like to think as positively as I can. I'm a very cautiously optimistic person by nature. So I try not to look at the glass as half empty.
Okay.
Yep.
All right. So we got a few more questions here. Angie says, if the hypothetical one, and this is at a hearing, was the same job as hypothetical two with limitations. Okay. So let me rephrase what she's asking. The judge gives a hypothetical, and the vocational witness says, based on this hypothetical, there are jobs you could do. Then the judge gives another hypothetical that says, let's assume 15% time off task or 2 or more days of work out per month. You can't really tell what the judge is thinking, but I'd say many judges at this point are always going to ask a hypothetical question, whether they're going to approve or just deny, that has all this off task time or missed days from work, just to complete their analysis. We don't know which hypothetical they're going to use, but I wouldn't assume because the judge gives one hypothetical that does have this very, very high level of off task or absent, that's what the judge is going to follow. It may be, or it may not be. So, you can't, sometimes you can tell by the questions. Andrew, you mentioned
Mhm.
sometimes the judge will ask one hypothetical, answers no jobs, you probably won. But
Right.
if the judge asks 4 or 5 hypotheticals or even 2, and one of them yields an answer of jobs and the other no jobs, but the other one is clearly one that would yield no jobs, that doesn't necessarily mean anything good or bad necessarily.
Right. My take on that, just to add to that, is what I always tell my clients. I usually tell them this after the hearing. I don't
Mm,
want them thinking about something like this beforehand, because I don't want to distract them away. Is if I have a judge that only asks one, or in some instances more than one hypothetical, where every single answer results in jobs, and they don't ask at least one of the form questions of being off task 15% or more, being absent more than 1 day a month, that we know will yield the answer no jobs,
mhm.
that pretty much tells me the judge made his or her mind up, and that they're going to deny the claim because they didn't even take the time to do that. But on the flip side of that, if they've at least included on their own, without forcing me to do it,
Mhm.
those form questions at the end, knowing what the answers are going to be, at minimum, that tells me that there's at least a chance they're going to consider that, or they wouldn't have asked it themselves. Now, sadly, probably if I looked at it quantitatively, more often than not, I would say they're landing with the first
Right,
hypothetical, not
right,
the
right.
second or third. But at least I know I've got a somewhat more fighting chance than if they didn't ask it at all. So I'll
Yeah,
I'll
yeah.
take that, again, thinking as positively as I can,
Do you
that
find
that's
it
the
odd
case.
that some vocational witnesses will use 10% off task as the threshold, others use 15%?
Well, not just do I find it odd, but I feel like there needs to be some. Like, I get that they're technically giving some opinions, quote unquote expert opinions. I noticed, by the way, interestingly, when you were mentioning this before, you said vocational witness, not vocational expert. Social Security loves to call them experts. We typically like to more so call them witnesses, because we question their quote unquote expertise. And part of the reason for that, in line with what you just asked, is that we get varied answers like that. I had a vocational witness at a case that's on appeal right now, and I feel like the judge shopped for this witness, because we had a prior hearing with the same judge with a different vocational expert whose answers would have approved the claim. Yet this one actually said 20% off task was the threshold, which I had
Mm,
never heard, and more than 2 days a month absent. So in other words, you could be absent 2 days a month and still be employable. Never have heard that in my life in all the years I've done this.
mm-mm,
1 day a month, or more than one at max, is
mhm.
all it would typically take. 15% is usually the cutoff for off task. And I've done some decent research where I could find cases at the federal court level to try to call that out. Um, it's tricky too, because again, if it's truly an opinion being given, whether it's a true expert opinion or not, they're basing it on what they call their experience and their knowledge and their education and background. But is that really a realistic response to say one person may view it this way, one person may view it that way? I don't know. And I don't know if there's a bright line answer to that, but I do find it somewhat frustrating that we don't have something a little bit more uniform. I would still say the vast majority of vocational experts would agree on that to some level, but it's extremely
Yeah, it's
mind-boggling to me.
very subjective, I
Yeah,
would say. All right,
absolutely.
Melanie Frost says, "Why do we continue to submit medical evidence even after the date last insured of a remand hearing? Don't
Mhm.
mind to know how relevant that evidence." I just think it just shows an ongoing problem.
Yep.
And look, the reality is, if you have a herniated, let's say that your date last insured December 31 of 2024, you have an MRI that shows a herniated disc in January 15th of 25. How likely is it that that herniated disc arose 15 days after your date last insured? Not
Yep.
very likely. So I think it's
Absolutely.
relevant. Again, the further you get from your date last insured, the less relevant it is. But if it's a problem that's been an ongoing issue, you
Yep.
know, it's probably not something that's brand new. Um,
Absolutely.
okay, Madeline, who's one of my uh, call screeners. Good to see you, Madeline, and glad you tuned in. Cordell Katana. Hello, how are you doing? Um, let's see here. Roy. Son has an appointment to reinstate SSD after working 5 years. His autism symptoms are getting worse. Is it better for him to take medical leave? Better to give SSA the medical records in person when applying. Just let them get them. Okay, so it looks like this is, so I'm guessing this is a reinstatement situation where somebody was on disability,
Mhm.
was taken off because they went back to work. Now they're
Right.
trying to get back on. Um, you know, there's a lot of details not here, but I'm assuming that you're probably past the extended period of disability, so it's almost like a new claim. This would almost seem like a new claim,
Right.
would it
Right.
not?
It's
Okay.
36. So if it's 36 months from the last disability payment or
Mhm.
more, then yeah, you're outside the extended period of eligibility,
Yeah.
and then it becomes a new claim. Yep.
And as far as taking, I mean, again, taking medical leave, that's almost sounds like he's still working. So you've
Right.
got a couple of things going on here. Is he working below SGA level
Mhm.
or above it? If he's above SGA level, that's a much bigger problem.
Yep.
The fact that he's worked, that's a good thing. I think that shows he's tried to work. Again, autism is one of these things, it's called the spectrum because it's,
Right.
it depends. Maybe he had a very unusual circumstance where he was able to get a job that he was able to perform despite his autism. And maybe that job has come to an end. But
Right.
I think you have to look at this as a completely brand new filing is what I would say.
Absolutely. I agree.
All right, Christy, another one of my regulars. Good evening. There are resources. This is going back to what you talked about at the very beginning. And she mentions medical schools often offer certain levels of care, sometimes on a sliding scale. That's a good point.
Oh yeah,
Very, very good
absolutely. Didn't
point.
even think about that. Like
Yep.
I know, like dental schools offer free dental
Yep.
clinics for people that
Yep.
can't afford or don't have insurance. Yeah, absolutely. Good
Okay.
suggestion.
And Edna and I had emailed a little bit to the last couple of weeks looking for assistance with medical services not insured. Again, I think that, there's probably a lot of different names, but, maybe reach out, community health boards many times will have those names. You may have to just really scout around to find out.
Right.
I'll tell you something else you can do. I've had people do this. Reach out to various doctors and see. Some of them have scholarships they offer. I know a couple of my clients have gotten,
Right.
concierge level doctors, really, high end doctors that take a percentage of clients
Mhm.
sort of as a community give back. So you don't ask, you don't get. So I think you got to definitely
That's
check
true.
that out. Okay. And Christy says, Edna, check your Department of Health and Human Services. That's exactly right.
Yep.
Okay. We got about 8-9 minutes left. So let's kind of speed through a couple of these.
Mhm.
Main event, PCP wants me to get an updated lumbar MRI of my SSDI with cervical and lumbar stenosis. Already had surgery and don't want another one by reluctance to get a issue with the CDR. I guess the question here is, you won't be punished or won't be held against you if you choose not to have an invasive procedure.
Yes.
I think an MRI might be one of these things where, they might look askance at not undergoing an MRI. I mean,
Yep.
because it's not invasive, it's fairly quick, and it'll tell them what's going on.
Right.
So I'm not sure that I would say no to that.
Yeah,
Agree?
I fully agree. It's testing. It's not something that's
Mhm.
has any danger whatsoever of making you
Yeah.
worse. Yep.
Okay. And this is a question we talked about before. I
Mhm.
personally cannot find a sedentary job. All my adult life has consisted of medical field, which is physical. It's all I know. Don't have family. And this is the issue in the Social Security world. They're talking about, again, hypothetical questions, hypothetical jobs.
Mhm.
It's based on your RFC, your functional capacity. Is there a job you could do? And again, there are entry level, unskilled, sedentary jobs. Not a lot of them, but there are some.
Mhm. Yes.
If you could do it, even if there is nothing you could do, even if you're making minimum wage, you can't support yourself. They don't care. It's just, could you do the job? So
That's it.
that's the real
That's
question.
all they need. And don't forget, at that stage of the review, the burden shifts from you as the claimant to Social Security. It's not a hefty burden for them to carry to show that there are jobs that exist in significant numbers in just the national economy. They don't even have to show a breakdown of what's in your region. But yes, that if they can show that, that's why it's so vital for you to have as much evidence at your disposal, particularly in the way of medical evidence and support from treating doctors that have long known you and are familiar with your conditions, to show why that would not even be possible. If you have physical limitations that prevent you from doing more than sedentary work, there's a good likelihood you've got symptoms that go along with that that lead to that. And one of the most common arguments I make at many levels, not the least of which is at the hearing levels and at the federal court levels, is if somebody that has the kind of impairment that causes pain, perhaps, and that's the reason they can't be on their feet or doing any heavy lifting, for most of those people, sitting doesn't magically relieve the pain. That just might lessen the intensity of it or lessen the frequency of it, but the pain is still there. And they're still going to have occasions where they're going to have to get up and stretch to move around, or they're going to stiffen up, or they're going to have to shift around, or they're going to have to
sedentary work by definition is standing and walking 2 hours a day.
Right, that too. And one of the things, this is a tactic I use frequently, and sometimes it does work. If I can get it established that my client, when they sit, have to sit in a specific kind of orientation, most frequently where you're reclined with your legs elevated, you can't work a sedentary job doing that because you couldn't physically reach. This is just a scientific principle. The body can't, if my legs are elevated, like I'm demonstrating right now, I can't reach the keyboard on my laptop here. I can't reach a workstation if I'm doing a job that requires me to work with my hands, because that's how I have to sit for a good portion or all day. And that's why I'm not employable even at a sedentary level.
Yeah. And also many sedentary jobs, they track your performance by the movement of the mouse. If you're laid back and you're not moving your mouse, it doesn't look like you're working. So, okay. This is something Christy says, talk about the Supreme Court of Nestor that ties the, I don't know. Do you have any idea what this doesn't ring a bell to me.
What is it again?
Says, also, please talk about the Supreme Court of Nestor. Maybe there's a case, the Nestor case, that ties this to Section 1102 of the Social Security Act. I don't know.
I'll try to look something up while you go to the next question. I'll see if I find something. It doesn't ring a bell for me either, but I could be wrong.
Okay. Let's see. Okay. Okay. Let's see. I think they're saying they can do it once a day, multiple times. Okay, so I think this is going back to the question of how many times a day you can do something. And, what Darlene's point here is once a day is not the same thing as 3 or 4 times a day, which, by the way, there's a term in Social Security when you do something occasionally, like it's 1/3 of the day, frequently it's 2/3 of the day.
Right.
One time is less than occasional, so that doesn't really count so much. Christina says hello from California. Hello, Christina. She's a regular. Good to see you here. Okay, being in Maryland, are you seeing success for long haul Lyme disease, specifically when symptoms increase? What's your experience over Lyme disease?
So I kind of term and group Lyme disease probably somewhere up there with long COVID right now, which I haven't had a great amount of experience with either one of those, just purely by coincidence. I mean, that's not to say I've never had a client that has suffered from Lyme disease, both locally and even in other areas of the country. It's usually not their prime impairment, although it does, from my understanding and experience with Lyme disease, and from what I've reviewed in medical records, boy, it causes a whole host of different problems and symptoms that really kind of look like something else on the surface. I mean, fatigue is certainly one of the biggest crushing blows that somebody that's suffering from any kind of long-term Lyme disease or long COVID, it's an effort to get out of bed in the morning and to raise their arm to brush their teeth. It's just that, it's that kind of debilitating process. So I don't necessarily treat a case like that any different than any other case in terms of when I'm developing the theory of my case and trying to summarize in as succinct a way as I can, but not overlooking into the details, how my client is limited on a daily basis in just everyday activities, and how that would again translate into an inability to work a full-time job 8 hours a day, 5 days a week. I'm drawing from that, and where there's medical records that support not only that the diagnosis is there and that it's been confirmed on whatever diagnostic testing they've done. Usually I think it's blood work. then that's my strategy. That's what I'm pointing to, is that this is a confirmed diagnosis. It's a known and accepted diagnosis in the medical community, and somebody that has this is not just being lazy. This is something that is actually affecting their faculties, and it's been a proven thing.
Yeah,
So,
I've had a couple Lyme cases. One of them, interestingly enough, was going back
Mhm.
before COVID, where you had to do live hearings. And actually, my client, it was a strong case, and I flew to Maryland.
oh, interesting. Okay.
I tried the case in person,
Okay.
um, and the judge approved it. My wife and I actually made a weekend. We had some friends in DC, so we
Okay.
went to
Nice.
DC, and I took the train to DC. But yeah, and this gentleman had gone to a specialist, like 2 or 3 specialists for Lyme, and we had really strong evidence. I'm like, I'm going to Maryland on it.
Nice.
I had another one where I had a person who had been up in New York, upstate New York, lived in Atlanta, developed Lyme disease, and we got that. So I'm 2 for 2 on Lyme cases. So you can win them.
Absolutely.
Okay, let's see. Kiana, I don't see your prior. We're kind of unfortunately running out of time, but I don't see your question. I'm sorry. You can please send me an email if you want. I'll try to answer it for you. Okay, we're going to just take one more because we're right at 2 hours here. Okay, and so Annie Davis makes a good point. This is a vocational issue. Son got let go from Walmart absent 1 day a month. So he has pulmonary arterial hypertension, which is a pretty significant problem. And real life, he missed 1 day of work, boom, he's gone. And I think most vocational witnesses will say for an entry-level, unskilled job or low-end semi-skilled job, 1 day a month is pretty much all you're going to get. And this is an example of someone who found that out in reality.
Yeah. Well, look, the reality is, especially for unskilled work, especially entry level, you're expendable. If you're not helping turn a profit for your employer, you are as invaluable to them as the next person they can get off the street to come do the exact same work, potentially for even less money. So, it all comes back to that. Sadly, that's the world we live in. But
it is. I think some vocational witnesses, that's one thing I've found fairly consistent. They recognize that for an unskilled job, entry level probation period, employers are really, really tight on that. They're not going to give you 2 days of work per month or let you be off task, which could be coming in later, leaving early. So anyway, all right, we're right at 2 hours. So we're going to end this here. Andrew, thank you very much for
having me,
for coming on. Hope we can do it again.
Absolutely.
And just so people know how to reach you, please give us your website, your phone number, email, whatever you'd like.
Let me, I'll put it into the chat right now.
Okay.
I'll do email, phone number, website, and my YouTube channel.
Okay. Yes.
So
and your YouTube,
you'll find me.
YouTube channel you've actually, I noticed you've go into some pretty extensive detail about things like you mentioned the one about hearing prep is an hour. So yeah, I would tell anybody who's going through the hearing stage, give it a listen. And again, break it up if you have to, but that's a very valuable resource because the more going into your hearing about what's going to happen, the better you're going to do. And really, I would even tell you listen to it a couple of times because you may be surprised the second time you listen to it or see it, you may pick up a couple of things that are different.
I've had clients and just random people that have viewed it that'll say, I went back and watched your video a second time, really picked up on some things. I've got clients that watch my video on consultative examinations. We go through them at the initial, and then at the reconsideration stage, I have them watch it again. Like, I picked up on something I missed the first time. It's nice to be able to pause it too, to take notes or to be able to go back to something. So there it all is. And
okay, great.
Yeah, by all means.
And look, I mean, I know, I've got a bunch of videos and you've got videos. We do this because we want to share what we know. And
absolutely,
this area can be a little bit of a black box, for lack of a better term, where they don't tell you what they're looking for. And so, why I have people like Andrew come on is because he's willing to share what he knows. And so I'm very grateful for that. Hang on for 1 second. I'm going to go ahead and end the live stream now, but we will again try to do it again soon. So everybody
Absolutely.
have a great week. Have a great first week of fall, and we will see you next week.
Take care.